Hello and welcome to GLC Law and Lore. Our guest today needs no introduction. He is known not just for his powerful judgments, but for the quiet dignity with which he ran his courtroom. Justice Abhay S is widely regarded as one of the most hardworking and diligent judges of our time.
You must look forward to work with a senior, strictly follows rules of ethics, who will never allow you to relax and make you work for 24 hours. That is the best training you will get in any chamber.
You had a practice as a counsel for almost 2 decades. What was the most difficult part about this transition?
I will not say that it was difficult, but it was drastic. Within 5 to 7 minutes, I realized that I will have to make a new beginning. A new process of learning I'll have to adopt. Because as a lawyer, you deal with 10 or 15 subjects. As a judge, you have to deal with so many subjects. And when I saw 50 to 60 lawyers standing in the court for mentioning, you get a totally different feeling that you have to face so many lawyers.
About post-retirement jobs for judges. As someone who served with great integrity all these years, what are your thoughts on post-retirement?
My personal view is you should not accept any office. After occupying a post of a Supreme Court judge, do not occupy any office.
Your favorite travel destination?
2 high courts where I have functioned and Supreme Court. Somebody looking for challenges after you graduate from a law school or law college. The real challenge is before the traditional course.
Hello and welcome to GLC Law and Lore, a podcast where we talk to eminent legal luminaries from Government Law College, Mumbai, get to know a little bit about their journeys, but more about them as people beyond the bans and counts. Our guest today needs no introduction. He is known not just for his powerful judgments, but for the quiet dignity with which he ran his courtroom, a space where every voice, no matter how small, was heard. From starting his practice in Thane to serving as a judge of the Bombay High Court, Chief Justice of Karnataka, and a judge of the Supreme Court, Justice Abhay S is widely regarded as one of the most hardworking and diligent judges of our time, with an unwavering commitment to justice. But what many people might not know about him is that he's a passionate photographer, a driving enthusiast, and he never missed his weekly ritual breakfast at the Carnatic Cafe in Delhi. GLC Law and Lore warmly welcomes Justice Abhay Oak, our final guest for season 1. Sir, to begin with, we'd like to take you back to A Road, Churchgate. Sir, how was your time like at GLC? Were there any moments or memories that have stayed with you?
It was a different legal education at that time. I was part of the afternoon batch. Our batch used to start at 10 o'clock. And we were supposed to have 3 lectures. But actually, there were never 3 lectures. There used to be 2. And there are 3 or 4 great professors around, starting from Professor Balsara. He, of course, retired when I passed out from first year LLB. Then there was Principal Balsara. Then Principal Taskar. We had Vadegaonkar, who was completely blind. And most importantly, Professor Pithawala. Perhaps Professor Pithawala was the most popular teacher. And I am told he continues to be still popular.
Yes, sir.
So, in those days, there are lectures, about 2 lectures per day. Hardly any extracurricular activities, maybe 1 moot per year. And I don't think there were any guest lectures also. I remember 3 or 4 guest lectures when judges of the Bombay High Court appeared and gave lectures. Only once I remember Nani Palkhiwala was invited to deliver a lecture. Otherwise, there were no other activities apart from attending lectures. And as I repeatedly said, there are attractions around. There was a British Council Library where they used to show video films. I'm talking about 1980.
Right.
But it was not possible to see video films. There was a beautiful library. Then there are, of course, Bombay High Court. And then third place was Wankhede Stadium. Because those were the days where Dulip Trophy and Ranji Trophy had all the importance. So we could see great people in action like Gavaskar, Vishwanath, Chandrasekhar, Brijesh Patel in action, Vengsarkar. So it was a treat to watch. So this was the Government Law College for you and surroundings of the Government Law College.
Yes, sir. So we also wanted to know what made you choose law in the first place. We've read that you had your eyes set on becoming an engineer. So what made you pivot and choose the legal fraternity instead?
See, I must correct you there. I had done BSc. In those days, it was 8-paper mathematics. There were 8 papers. I had done that. And though the subject was tough, I had very good marks. So I had various options open. Firstly, after 12th, I had option to go to engineering college. I thought that I'll do something in pure science. And after BSc also, I had option of joining MSc in computer science course, and various other postgraduate courses were there. But I decided to join law, and I must candidly tell you, I don't remember exact reason why I did that. Maybe it was in the blood, it was in the family. Therefore, one fine morning, I decided that I'll take admission in government law college. And admission was very easy at that time. You have to apply. They used to call you for interview. And most important thing was first semester fee was 127 and second semester fee was rupees 87.
Right.
So there was no real challenge to get admission into government law college. All that was required, if I remember correctly, that first class in graduate course from Bombay University.
Right. So, like you said, initially you started your practice at Thane. And I remember attending the inaugural of the Bhiwandi District Court, and you had said, and I quote, district courts are not secondary, they are the core of the judicial system. So, how did those early years or those early experiences contribute to your journey?
Whatever little work I could do as judge of the High Court and Supreme Court, substantial credit must go to my days in trial court, because that is where you get real exposure, in the sense you know what is pleading, you know how evidence is recorded. And it's not about only drafting pleading. It's not a simple thing. When some litigant comes to you to draft a plaint, it's not that you take instructions from him, see the documents and draft a plaint. You have to apply your mind that what relief can be possibly granted by the court to the litigant, who are going to be your witnesses,
Correct.
what evidence you are going to adduce. After that kind of clarity is there in your mind, then you start drafting the plaint. So the basic legal learning you get only in the trial courts.
Correct.
And how pleadings are drafted, how evidence is recorded, how documents are marked as exhibit. Now, this you can learn only in trial courts.
Correct. But sir, nowadays we've seen some kind of shift. A lot of councils avoid districts or session court completely. In fact, a lot of students only dream of the High Court or the Supreme Court. What are your thoughts on this shift in perception?
Maybe that with the passage of time, uh, some people feel that practice in High Court is more lucrative, but that is again not correct. I'll give you one example of Ram Jethmalani. According to me, Ram Jethmalani was one of the greatest lawyer India has produced. And Ram Jethmalani regularly used to appear in the Metropolitan Magistrates Courts in Mumbai, in Sessions Court. He used to go to districts and appear even in Judicial Magistrates Court.
Right.
So actually, for a great lawyer, there is no inferior court.
Correct.
Ultimately, he is concerned with practice before the court. And his duty is to assist a litigant to get justice. So if at all this is the concept, that some people feel that they should not go to the trial court or first appellate court to work, I think that is completely wrong approach.
So, a few years into your career, you joined the chambers of Mr. VP Tipnis. What made you choose him, and how has that influenced your journey? Because we know, at least in litigation, a good mentor can make or break your career.
See, that days have changed. Today, when a law graduate feels that he wants to join traditional legal practice, he will study a dozen senior lawyers, find out how is that lawyer,
Right.
and then venture to approach him. The considerations are different. In my days, considerations were different. Firstly, late Justice Tipnis was known to be a brilliant lawyer and man with a discipline. That was the one reason. But the real reason was he was also a resident of city of Thane and used to stay very close to our place. And though he was much younger to my father, they had very friendly relationship. So I used to observe him. I knew that he is practicing in High Court. So therefore, when I thought of practicing in High Court, the first name which came to me was of Justice Tipnis. That is how I joined him.
Right. So, talking about the next phase of your career, one of the most pivotal stages are elevation to the Bombay High Court. Sir, but before that, you had a practice as a counsel for almost 2 decades. What was the most difficult part about this transition?
I will not say that it was difficult, but it was drastic.
Right.
In the sense, I remember my first day in the court, 1st September 2003. I sat in historic room number 52, the Chief Justice's court, along with Chief Justice C.K. Thakkar. And somehow I was very confident when I took the seat, because in very court before bench headed by Justice Thakkar, I used to appear every day in 5 to 6 cases. But within 5 to 7 minutes, I realized that I will have to make a new beginning, a new process of learning I'll have to adopt. Because as a lawyer, you deal with, 10 or 15 subjects. As a judge, you have to deal with so many subjects. And when I saw 50 to 60 lawyers standing in the court for mentioning, you know, you get a totally different feeling that you have to face so many lawyers.
Correct.
So the challenge was to adapt to new role where, you can't argue.
Right.
You have to hear and decide. And at some stage, at least, you might have to forget that you are a lawyer and you have become a judge. And that's the difficult part. In the beginning, when a case is called out, sometimes you don't concentrate on what lawyer is arguing. You start thinking what you could have argued, in what manner you could have argued, or which is the best point available. So initially, you have that mindset and you have to change it with great deal of effort.
Correct. Sir, this question is a little personal, but during your tenure at the Bombay High Court, while hearing some PILs regarding noise pollution matters, your bench had faced some allegations of bias. Although they were later withdrawn following strong support from the legal fraternity, but that does raise questions about the kind of pressure that judges face from powerful quarters. How did you personally navigate such a challenge?
I'll start with last part of your question. Firstly, I must tell you, I have been a judge of 3 constitutional courts for 21 years, 8 months, and 25 days to be precise. I never faced any direct pressure from any authority, maybe government, maybe political leader. Nobody even attempted to do that. All that you face is, you receive some threatening letters, some nasty letters. Somebody addresses a letter against you to President of India, publishes it everywhere. But I have not come across where somebody in power tries to pressurize you, even indirectly. At least it has not happened to me. I can't say about others. So we don't face that pressure. The real pressure is of deciding it correctly.
Correct.
When you sit in the constitutional court, for that matter, any court, even as a civil judge, there always a pressure to decide it correctly. Now, talking about the stand taken by government of Maharashtra. Now, since you are also practicing, you must have realized that normally in High Court, 50% of the cases are of the government. Either government is the petitioner or mostly it is respondent. So, as a judge, I must have decided hundreds of cases where state of Maharashtra was the respondent or it was a petitioner. Maybe in several cases, I may have decided in their favor. But surprising, the allegation was that Justice Oak entertains bias against the government of Maharashtra. That was a precise sentence, if I recollect correctly. And according to me, it was very ridiculous. It was, to put it very bluntly, I was handling a very sensitive case. You know what was that case? The main issue in the case was whether for Ganpati festival and Navratra festival or other religious festivals, people can be allowed to erect pandals on footpaths and roads in such a way that the traffic is blocked or pedestrian movement is blocked. That was the one issue. Secondly, issue of using loudspeakers and creating noise pollution. There are instances where for such festivals, without license, loudspeakers were used. There are instances where the silence zones were not maintained. Then there was also an issue in that case where it was pleaded that by a particular religion pleaded that right to use loudspeakers is part of Article 25, when that is negated by that judgment. So it was a very sensitive case. And maybe, I don't know what exactly transpired, but maybe it was an attempt to ensure that the case goes to some other bench. And that was the reason for that allegation. And even on the same day on which this happened, I continued to hear cases where government of Maharashtra was party before me.
Right.
So in other cases, nobody said that you entertain bias against government of Maharashtra. So the allegation of bias was not case specific. It was party specific. And I'll add something here. And then I remember it happened on Thursday, if I am not wrong. Friday was Ganesh Chaturthi day. This is significant. The reason is Ganesh festival start on next day. And the very sensitive issue was regarding silence zones. So Friday, Saturday, Sunday were holidays. If I recollect correctly, on Monday, Bombay Bar Association passed a very strong resolution against the Chief Minister, the Chief Justice and Advocate General. And it was followed by AW and other associations. And there was online petition made by citizens, which was signed by about lakh of people, if I recollect correctly. So this was one case where not only bar, but the common man stood for independence of judiciary.
Right. It tells us about the relationship between public trust and the judge.
Right.
Right.
So relationship, you talk about relationship. What should be the relationship between the court and the executive, or court and the government? I remember what Chief Justice Venkatacharya said after he was sworn in as Chief Justice of India. Maybe some minister, maybe Prime Minister, I don't know exactly. Somebody told him that, Chief Justice, the relationship between government and the Supreme Court should be cordial. He immediately said in split second, it cannot be cordial, it has to be correct relationship.
So, like you said, you've had a judicial career spanning over more than 2 decades. So, do you think the idea of what you thought meant to do justice, like people say, evolved over time? For example, from your first day at the bench to your last.
See, concept of justice remains the same,
Right.
but with passage of time, you learn so much. See, as a judge also, you learn so much. When you take oath and sit in the court, you are different than what you are after 10 years of judgeship. So the concept of justice remains the same, but with your experience, you acquire better techniques to ensure that justice is done, better method, better way of disposal. Or, for example, there are matrimonial disputes. When you begin as a judge, you of course make an attempt to bring about settlement between the parties. But when you grow as a judge, maybe after 10 years, you are equipped with better techniques to ensure that parties come together or they decide to take divorce by mutual consent. So the experience teaches you many things, but the concept of justice remains the same.
Correct. So, in your experience, have there been any cases that have stayed with you, but not for its legal complexity, for the human story or emotion behind them?
There are many, but one case I remember, I was a very junior lawyer and some NGO gave that case to me. It was, I am talking about 1988 when I argued that second appeal. It was a case of a very poor person who was resident of a very backward region in Nasik district. And in late 60s, he was employed by Jilla Parishad as a carpenter. And though he continued to be in service, he was not given formal letter of confirmation. Then his service was terminated. He filed a suit for declaration that termination was illegal and he wanted reinstatement. The suit was decreed, the appeal district court confirmed it, and High Court it remained pending for 12-13 years. By that time, he had reached the age of superannuation. Now, the poor person used to come to me, and actually, sometimes I had to pay him bus fare. He was so poor. And then in second appeal was dismissed. If I remember correctly, it was dismissed by a very great and eminent judge of Bombay, Justice M.L. Pense. And after we succeeded, he got salary, he got pension.
Yeah.
That case always remained in my mind. And there are, of course, cases and cases where, especially on the criminal side, when you hear criminal appeals and you find while hearing criminal appeal that it's a case of no evidence, and somebody undergoes sentence for 12 years, 13 years, 14 years. These are the cases sometimes affect your mind,
Right.
because when you see it was a case for acquittal, man continues to remain in jail for 12 years, 13 years. So his life is lost. His entire family suffers during this period. So these are the cases you carry in your mind. There are cases and cases like this.
Right, sir. So now fast forward to your last day at the Supreme Court. You had said the job of a judge is not to be popular. And I feel that's a very important discussion because in this era where every word from the bench can go viral, do you think judges are forced to second guess themselves? How can a judge stay focused on the substance rather than the spectacle?
This is a new phenomenon that everything which just says is quoted in the social media. Somebody keeps on
Yes, sir.
tweeting it and all. But I think as judges, we should not bother too much about it, because, those who are on social media, necessarily they do not have trained legal mind. I'll give an example. A case comes up before a judge. Judge finds that in equity, the petitioner has a good case, but in law, he does not have a good case. Then, as a judge, I may take the lawyer for petitioner to the task. And reason sometimes is I want to bring best out of that lawyer. Because we hear 80 cases, 90 cases, 100 cases every day. So, as a judge, I want to ensure that the lawyer makes research and he comes out with something good, something better, so that justice and equity can go together. So there are so many things we say in the court to bring best out of the litigant. Now, for example, I'll give an example. There are cases and cases where we issue contempt notices. Now, there are sometimes very serious cases. Serious in the sense that court has directed that pension should be given to somebody. The government doesn't pay pension. Then we issue notice to say chief secretary or secretary of the concerned department. Now, we say when secretary appears, we say in open court that I am giving you 7 days time, but on 7th day, you will not go back to your home. You will go back straight to the jail. Now, those who are not conversant with the court functioning, they will feel that what kind of judge is this? He's threatening.
Correct.
He's threatening a IS officer or some superior government officer. So, several things we say in the court for different reasons. Sometimes it has nothing to do with the merits of the case, because ultimately, why we say that, as one thing I told you, to bring best out of the lawyer. We want to give signals to litigants also. For example, if matrimonial litigation is there, when parties are reluctant to patch up in the sense that two ways of patching up. One is they come together, other is they agree for divorce by mutual consent, and so that all cases are closed. So sometimes openly we say, look, if you don't settle, you'll be spending 25 years of your life in courts. It's a threat given to litigant, but why we give that threat? Just to ensure that they should see the reason and settle the matter. But if you are not conversant with the court working, somebody will tweet only on that Justice Oak threatens the parties. So, but I personally feel that when we say so many things in the court, we say it because we want to discharge our duty as per our oath. Therefore, what social media says, what Twitter says, Instagram says, we should not be bothered about it. If somebody wants to misunderstand the judges on the basis of what they say in the court, in that case, I think we should not bother. Only one aspect I will tell you. When we say about merits of the case, you know, now whatever you say about merits of the case, that must form part of your order.
Correct.
It can't be that you say something strongly. For example, there's a case where petitioner says that my right under Article 19(1)(a) has been infringed. Then as a judge, if I find that that is true, I will say several strong things to the government or to the opposite party, but that must form part of my order. Right. So this is a distinction. Several things we say it for different purposes. But to repeat what I said, as a judge, I should not be bothered about it. What people feel about what exactly I am doing in the court, so long as I am very cautious, I am working as per my own conscience for discharge of my duties as a judge.
Correct, sir. So now this next question, I know it's a little repetitive, but delays and pendencies still remain one of the biggest problems that judiciary faces. What, according to you, are the mindset or some systemic changes that can help address this issue at its core?
See, it can't be a simple answer to this. It's a combination of various factors. The first is, of course, our judge strength has to increase.
Correct.
I am not talking about High Court and Supreme Court. The minimum judge to population ratio, that is, number of judges per million, should be at least 50. That's what Supreme Court said in 2002. But today we are struggling at 20 or 21. This is first reason. If you just walk few meters from here and go to the Esplanade Court, you will find that cause list of every judge has 100 matters, 150 matters, plus those remand matters where accused are produced. How judge can deal with so many cases?
Correct.
He can deal with 5 or 10 other cases, dates will be assigned. So therefore, we must have such infrastructure that will accommodate more and more judges. We need infrastructure for that. It can't be that you appoint judges and disposal improve where the judges will sit. This is number one. Number two, I am talking here about the High Court, mainly about High Court. We call it as a welfare state, but in welfare state, for smallest reason, people have to approach the writ jurisdiction. I'll give few examples. One, that you purchase a property by registered sale deed. The Land Revenue Code says that, or the rules say that, rules under Land Revenue Code, that on the basis of sale deed, your name has to be entered in the revenue record of the property. But revenue officer don't act. For such simple reason, people have to come to the court. There are cases where pension is denied. Though person is entitled to pension, he has to come to the court. For smallest thing, people have to come to the writ court. So someday we must make a systematic study of this, that how many cases common man is filing for writ of mandamus. And why this happens? Because there is a system failure. So therefore, the system must ensure that for smallest thing, person should not be forced to approach the court. Second thing, I am talking about criminal matters. Whenever there is a case made out for grant of bail, sometimes our courts are not granting bail. So matter is carried up to Supreme Court. And you will find in Supreme Court, most of these bail matters don't take more than 3 to 4 minutes, where bail is granted or it is dismissed. There is one more thing that is also of equally important. Now there is a tendency to file very bulky pleadings, lead very lengthy evidence, and make very long arguments, which is followed by very bulky written arguments. So time has come where there should be ceiling imposed by the judges on how much time lawyers are going to consume. Strict timelines will have to be fixed.
Correct.
Because it is high time now we all realize that every second of court's time is very precious.
Right.
And we don't have that approach at all in our system. So it can't be that, of course, I must tell you candidly, if the judges are strong, they will not allow the lawyers to hijack the court time. So therefore, this area where how much time we are going to consume in each case and how lengthy are going to be our pleadings. And now this is coupled with tendency to cite large number of decisions, relevant, irrelevant, repetitive.
Correct.
And this may be because the legal profession has become more competitive, more commercial, and the age-old concept which remains today that a lawyer has to be first officer of the court and then mouthpiece of his client. Whereas that age-old concept is being forgotten. So these are 4 or 5 aspects uh, which are very relevant when we talk about reducing arrears. And secondly, you know, society is also responsible. Society in which we live is also responsible for creating more litigation. Now, for example, matrimonial disputes is one category of dispute now which is going to destroy our legal system in the sense that one matrimonial dispute creates about 5 or 6 grassroots level litigations. In our society, there are no checks and balances. If there is a matrimonial dispute, there is no machinery available in society. People have to approach, either the wife goes to the police and files a complaint under 498A. So that machinery is not available in society. So everybody comes to the court. So this is the combination of various factors. So finding solution to arrears or long pendency or delays is not easy in our system.
Right. Right, sir. Correct. So we've read, and of course, subject to correction, that almost 40% of your judgments in the Supreme Court have been in the realm of criminal law. Is there something about criminal law or criminal jurisprudence that resonates with you?
First thing is, you may be right, 40% judgments are in criminal law. But there I must say that we as judges, we don't have choice.
Right.
Ultimately, we hear the matters which are entrusted to us by Chief Justice. Criminal law is very important subject because this is one subject which has direct nexus to the most important fundamental right conferred by the Constitution, that is Article 21. It is all about Article 21, upholding the liberty. And while you uphold the liberty, those are those age-old principles which are of course subject to some exceptions created by statute. Now, one is that guilt of an accused is proved, must be proved beyond reasonable doubt. And always burden is on the prosecution
Right.
to lead evidence to prove the guilt. Of course, there are now some of the statutes where there is a reverse burden. And then the other principle that bail is the rule and jail is the exception. So when you talk about criminal matters, it is the object is twofold. One is that, of course, law and order in the sense that if there is legal evidence to show that a person has committed an offense, then he must be brought to book, he must be punished because it has effect on the society that if wrongdoer is punished, he is sent to jail, it has some effect, we call it a deterrent effect. But at the same time, you have to uphold liberty of individual. As I gave you example, there are cases and cases where people undergo incarceration for 13 years, 14 years, and after 13, 14 years, the court says it's a case of no evidence. You must have come across cases where there's a death penalty, and under the CRPC, death penalty has to be confirmed by High Court. In confirmation cases, the High Courts have granted acquittal. So imagine the plight of that accused. The hanging sword of death remains for maybe 1 year or 2 years. So this is the importance of justice delivery system on the criminal side.
Right, sir. Correct. Now, sir, for the last question for this segment, when you finally stepped away from the bench, was there something you hoped you had left behind in the institution itself, or your judgments, or in the people you worked with?
Later when I'll tell you, legacy is a concept under Indian Succession Act, where you leave legacy in the form of your assets to your legal heirs.
Right.
I believe judges do not leave any legacy, and or rather, judges should not think whether they have left any legacy. What judges leave is their judgments and nothing else. So, what I personally feel is that you have to do your best as a judge. And when that day arises, when you have to demit office, you feel sad, of course, because you can't deliver justice. But from that day onwards, I mean, you should not think about any legacy at all. You have passed orders, you have delivered judgments. So it is for the others to decide how the judge has performed. So there's nothing like legacy. I don't think any judge leaves behind anything except his judgments.
Correct.
Because you must also remember one thing: institutional judiciary is much, much bigger and greater than individuals. CBI as individuals, we come and go, but institution remains.
Right, sir. This brings us to the end of the first segment. Now, starting with the next segment, the legal segment. So, we would like your take on certain contemporary legal issues. The first one is that after every election, we see headlines talking about the pending criminal cases against various MPs and MLAs. Given the immense responsibility we place on our elected individuals, do you think there should be a legal bar against these candidates from contesting elections, or do you think that risks undermining the principle of innocent until proven guilty?
See, basically, you have to remember one thing. When we talk about pending cases, we must differentiate between the two. One category can be that a person has been convicted.
Correct.
That applies as a disqualification only if the conviction is suspended, not sentence. Conviction is suspended, then he can contest. So if there is a conviction and if the conviction is not suspended, he can't contest. Then all other cases are in the realm of allegations, because either there is FIR registered or there is a charge sheet filed. Allegations may be very serious. There may be allegations of we can say money laundering, or to an extent that there may be allegations of POXO. Will it be correct to say that only because FIR is pending against an individual, a politician, or charge sheet has been filed, he should not be permitted to contest the election? The reason is there are cases and cases where we find the FIR is frivolous, the charges are frivolous. So it can be a very easy tactic for a political opponent to ensure that FIR is registered with some serious allegations against uh, the rival politician. And then will it be correct to say that he should not contest the election? So it's not a simple issue, because when we talk about this, then you are talking about morality. It is moral for the candidate to contest. But what I feel is that if we say that a case is pending, a candidate should not be allowed to contest. It will have very drastic consequences, in the sense that against a very good and competent politician, allegations can be generated. I think answer lies somewhere else. If you have matured voter or voters, they can give their verdict. If they find that some candidate is contesting election, he has very serious cases against us, say, for example, POXO or money laundering, then the voter is all powerful to ensure that such candidate does not get elected. But that does not happen, because the pattern of voting is polarized. One particular voter votes only for a party and not for a candidate. Maybe at smaller level where election is of, say, municipal corporation, maybe on some occasions if voters feel that candidate does not have good character, it may happen that he may get defeated. But in Vidhan Sabha election or Lok Sabha elections, the voter is polarized on party lines. So therefore it is not happening. But as a proposition, uh, it requires lot of debate whether there should be ban.
Correct. Right, sir. So now for this next question, there's often public debate about post-retirement jobs for judges. Some people argue that it might risk undermining uh, public confidence in the judiciary. As someone who served with great integrity all these years, what are your thoughts on post-retirement jobs? So especially those involving government appointments.
Uh, I will divide my answer into two parts. First is my personal view.
Right.
My personal view is, I'm talking about Supreme Court judges. My personal view is, you should not accept any office after occupying a post of a Supreme Court judge. You should not occupy any office. That's my personal view. Let us go to the second segment. If you read some of the legislations like IB Code, Insolvency and Bankruptcy Code, or National Green Act, which creates National Green Tribunal, there is a provision in law that person who has been a judge of the Supreme Court will occupy the office of, say, chairman of NGT or chairman of NCLAT. So the law creates these posts which are meant for retired Supreme Court judges or High Court judges.
Right.
So law itself permits it. But there, my personal view is, I am asked about it. All right, law permits it, but still there has to be cooling period. Maybe of 2 years, maybe of 3 years. Legislature will have to have debate on that. Cooling period is required. That's what I personally feel. Allegation is that, when you are approaching age of retirement, then your approach changes because you want to have one particular post. If there is a cooling period, the process of selection will start. He will not be entitled to participate in the process of election, a retired judge, say for a period of 2 years. So much water flows. So even if law provides for judges occupying such posts, there must be a cooling period. That's the only answer. But as I said, personally, I believe that as a retired Supreme Court judge, I should not accept any post.
Correct. Right. So now moving on to the next segment. This is the fun segment of the podcast, the rapid fire round. If you could please answer with the first thing that comes to my mind, these are just very short questions. If you could add one new rule to courtroom procedure, what would it be?
Lawyers should not be permitted to argue for more than 5 minutes.
What's your favorite chamber tradition or one that you secretly miss?
A chamber tradition as a judge or as a lawyer?
So anything.
Okay. I don't think I miss any chamber tradition because I continue with that tradition. So I don't think I miss anything.
So is there any favorite one that you have?
Favorite one is long working hours and discipline.
Right. So your go-to stress buster after a long day of hearings?
I don't think anything like that exists as far as I am concerned. If you want me to say something, for me, the only thing was morning walk.
Right. One thing your co-judges found hard to keep up with while working with you?
While in Bombay High Court, I can say that sitting long time after court hours in the court.
Right. So one historical figure you would love to have a courtroom debate with?
Justice V.R. Krishna here.
Right. Your favorite travel destination?
2 high courts where I have functioned and Supreme Court.
So a book you would recommend to every young student?
Roses in December by M.C. Shagala. I'm talking about law students, naturally.
Yes, sir. So hypothetically, if you had to choose one co-counsel to argue all your matters with, who would it be?
It's a very difficult answer. Very difficult to answer. I'll put it this way. I would not have chosen a co-counsel. I would have argued myself all my cases.
Right. So if you could click a picture of just one place anywhere in the world, what would it be?
It will be of any place in Sundar Nasar in Delhi.
Right. So if you had to be known for something completely unrelated to law, what would it be?
As a decent human being.
Right. Right. So that brings us to the end of the third segment. Now, for the first time ever, we are going to open the floor for questions from the audience that year.
Good afternoon, sir. I'm a student of JLC. You've come out very strongly against under trial incarcerations for a long periods of time. Now there are many judgments of the Supreme Court which say that Article 21 will override the twin conditions, especially in the context of the NDPS. But still, we see that there are a lot of high courts and the Supreme Court itself which will not grant bail. Unfortunately, even if the person is in jail for 2 years, 3 years, they will pass orders like start the trial in 6 months, uh, and similar orders to that. My question is, why can't there simply be a declaration of a bare minimum specific number, say 6 months? If your trial does not start after 6 months, unless you are a dangerous person or you are a flight risk, etc., you Article 21 will just kick in and you ought to be granted bail without any conditions. That's my...
See, basically, these are the rules. You are right, absolutely right, that if there is long incarceration, trial is not likely to be concluded within reasonable time, and Article 21 must come to rescue. Maybe it may be a case under UAPA, PMLA, or you said NDPS. But it's very difficult to fix such time. It all depends. I'll give an example. In a given case, suppose trial has not proceeded, say, for a period of 5 years. But on facts, if it is pointed out that it is the accused who has delayed the trial, he filed some proceeding, there was a stay, or he kept on seeking adjournments. In such a case, Article 21 will not come to his rescue. It is he who is responsible for delaying trial. So there can't be a mathematical formula for this, because when you deal with bail applications, each case is different. Each case is on facts. Each individual is different. Each accused is different. The allegations are different. And as you rightly said, there may be cases where there are strong antecedents against a person, or in the past he was released on bail and he has committed some offenses after he was released on bail. So it is not possible to lay down any mathematical formula. Of course, that mathematical formula you will find in earlier section 436A of CRPC.
Half the sentence.
That's right. A new one also is there. I think it is 1/3 now. 1/3 in certain cases. So it's not about mathematical formula. Each case has to be dealt with on its own facts, keeping in mind the principles which are laid down.
Then like what's the best solution? Like how do we prevent such long periods of incarceration without trials? Like,
See, there are 2 or 3 issues associated with it. One is that we don't have adequate number of criminal courts. Second, in some states, though there are adequate number of criminal courts, prosecutors are not available. For 2 or 3 courts, there is one prosecutor. So these are the factors which delay the trial. So it's a very complex scenario. But fact of the matter is, wherever protection of Article 21 is deserved by an accused, it must be extended to him. That's the bottom line of this.
So my question is related to what you said, the pressure of deciding a case correctly. We've all heard and read the judgment of the authored in 2018 regarding the BAJ environment matters regarding protection of mangroves. My question is, in cases where public interest is pitched against public interest, the state files petitions saying that certain projects are necessary for the public, whereas environment itself is also in public interest. What is the approach, according to you, that a judge must have to decide such issues? Because it's entirely possible that both the issues are in public interest. But what, according to you, is the criteria, or 2 or 3 things are the parameter according to which a judge must approach this issue?
Firstly, within the framework of existing concepts, I will say that there is a theory of proportionality, in the sense that you want to construct a bridge, and in the process you want to destruct large area which is fully covered by mangroves. So proportionality has to be seen, whether it is really necessary to construct a bridge. I'll give another example. For constructing a road, if you are required to fell so many trees, proportionality has to be considered. Is it so necessary that a road should be there, and for that purpose you want to get rid of thousands of trees? This is the existing concept, but I advocated this in some of my judgments also. there is a concept of sustainable development. Our problem is that we have wrong concept of development. In the what is development? Someday we must apply our mind to this. Constructing flyovers, constructing skyscrapers, constructing huge buildings and other infrastructure. Is it development? The real development will be provide affordable housing to common man in any city. Provide affordable facilities of education, medical facilities to common man. That is the concept of development. What Constitution has promised to common man, the concept of development must revolve around that. Now, for example, I'll give an example. I'm not talking about city of Bombay. Maybe project anywhere in state of Maharashtra and in coastal area where government says that destroy mangroves over a large tract of land. Mangroves are destroyed. We'll know the drastic consequence of destruction of mangroves maybe after 10 years, 15 years. When the high tide water will start entering, maybe drainage system. So when we take such decisions, we don't contemplate what is going to happen if we easily allowed environment to be destructed. So this is this conceptual mistakes we are making.
Good afternoon, sir. Thank you for the session. This question comes somewhat from a personal experience. Somebody who's on the cusp of graduation. And as you briefly touched upon the topic of mentorship in the beginning of the session. So in your vast career till now, what are some of the qualities that you have seen that are essential for a person, especially a first generation lawyer, to look upon a mentor in the initial years? And how do you approach such a mentor when you don't actually come from a law background where you can ask somebody to introduce you, and what is necessary? Like, you must know your law that you want to work on, and what should you look upon on a mentor and some essential qualities?
You are talking about traditional thing that you are talking about your senior in practice, as we in common parlance call you. I think you must find out a senior. First test, I'll tell you, who will never allow you to relax and make you work for 24 hours. That is the best training you will get in any chamber. That is number one. Secondly, you must look forward to work with a senior who strictly follows rules of ethics and maintains moral standards. These are the two very vital aspects that unless you get opportunity to work and you are made to work, there is no real mentoring. And other part, as I said, strict adherence to rules of ethics. That covers everything.
Good afternoon, sir. So my question is more on the lines of your personal life and personal life of lawyers itself. So you've been known for your tireless dedication to your profession. And my question essentially is, how have you managed to strike a balance between your professional life in these 4 decades or so and your personal life, knowing that you have worked very long hours on most days?
Yes, sir. See, I can't talk about balance because that balance can't be there. If you are working round the clock, balance can't be there. But it is all about finding time for your family. You must find time for your family. You just can't think about maintaining balance. There's no question of maintaining balance. But when you are needed, you must find time for your family. That's the key to the success. Because in our system, if you want to succeed as a judge or succeed as a lawyer, you find it impossible to maintain that balance. If you are comparing yourself with the life-work balance in European countries or USA, you just can't think about it.
Hi, sir. With the recent new laws coming in, that is the IPC, that is the BNS, BNSS, and BSC, do you think they address significant changes to the law system?
First is candid part of my answer. that the laws have come from 1st of July 24. So I got very few opportunities to deal with the provisions of law. Broadly, I feel that there is no drastic change. But if you want to ask me about what is a drastic change, only one drastic change is brought about in the new criminal procedure code. There is a concept of filing private complaint, and on private complaint code takes cognizance. Now there is a really very good provision added that accused will get hearing before cognizance is taken. So that is one provision, which is a very salutary provision, I can say that. With little experience I have of these three laws, I don't think it brings about a major change. All that is happening is, most of the provisions in Indian Penal Code and the new code are word to word same. Only thing is that huge struggle is involved to find out which is the corresponding provision. So same is the case with law of evidence and the new form of CRPC. I really don't think, barring few provisions here and there, they bring about a major change. I don't think so.
So now that we've come to the tail end of this podcast, do you have any advice for our audience or the viewers watching, law practitioners, law aspirants?
This is one piece of advice which I am giving over a period of time to those who are fresh law graduates. That piece of advice is that our system needs good lawyers in traditional legal system. The reason is that it is our traditional legal system which gives justice to common man, and therefore traditional legal system needs lot of talent. And I believe that if somebody is looking for challenges after you graduate from a law school or law college, the real challenge is before the traditional courts.
Correct.
So, of course, I can't say every student must go to traditional court and practice there. But we need to encourage the students to take up traditional practice. And personally speaking, that is one category of practice where real thrill is involved, because you have to think on the feet. Not only that, you have to think on the feet, you deal with human issues.
Correct.
You have to deal with patterns of human behavior, human psychology. So therefore, I always say that many bright students should aspire to join traditional legal practice. And last piece of legal advice is, some of you must also think of joining judiciary.
Right.
Because unless we have quality amongst the judges, we can't have a good legal system or justice delivery system. So these are the two concepts which every student must keep it in mind.
Thank you so much, sir. It was a pleasure to have you here with us. This is Dhun for GLC Law and Law. Thank you so much.
Thanks so much. I enjoy company of young lawyers and young law graduates. Thank you.